Thank you for coming this morning. I know it's early for me, maybe not for the rest of you to go in our regular hours. But thank you very much. As some of you may know, Coleman and Horowitt is a transaction litigations firm that was established in 1994 to serve businesses and their owners. We don't try and be all things to all people. We just focus on representing the businesses in litigation transactions and then helping their owners as well with wealth preservation and other business transactions that they may have. I'm the managing partner of the firm and was also one of the founders, and which we started with Bill Coleman in 1994. My bio is on the page here. Sheryl Noel is my partner. She is the head of the firm. She works in the firm's litigation and transactions department. She's head of our collections department, which handles routine, which handles commercial and what are called retail collections, which are consumer collections throughout the state of California. And she's also helps in business transactions and estate planning, wills, and trusts. In addition to being an outstanding lawyer, she's licensed as a CPA. Although she does not practice accounting, she uses her skills for good. I would say for good instead of evil, but there is no evil. She uses it for good in helping our clients collect money. Next slide. Today, we're going to touch on a series of topics that over the years, I've noticed. I started my practice in 1981. Before I started my practice, I was a law clerk, and I worked in the field of civil litigation with a focus on breach of contract and collections work. And what I noticed that there was, and then after I started my practice, I started taking on commercial collection work directly through clients, as well as through agencies and forwarders who would send us the commercial collection work from around the country. And I started seeing a pattern of what got people into problems, the lack of action and that they took that led them to needing to hire a lawyer. And I thought that we want to try and impart to you ways to avoid having to use us or another collection law firm or collection agency. Talk about that, but also what happens if you do. So today we're going to talk about learning how to avoid a collection problem in the first place. That's always a good place to start. Identifying when you do have a collections problem, because we found that a lot of our clients didn't understand it. They're making their product. They have one or two people working on credit. They really didn't identify where there's a problem. And now you start having a big problem that could affect your business. Steps to take when a collection problem arises. The various legal remedies you have in addition to just filing a lawsuit. Alternatives to litigation, because some people believe that filing suit is the only option. And then information about bankruptcy work, what creditors should know about bankruptcy. And at the end, we'll hopefully have some time for questions. So moving on to the first area, which is how to avoid a collection problem and a collections problem. I'm going to turn this over to my partner, Sheryl. Sorry.
Good morning. I think probably the first and the most important thing when we look at filing a lawsuit is making sure we have the right plaintiff's name. And so when you're using a credit application, or if you're not even using a credit application, make sure that you know the plaintiff's name. From a consumer standpoint, you often have their name, but they change names frequently. So make sure you get a date of birth and a social security number so that if we do have to file suit, we can figure out who the correct person to sue. If it's a commercial matter, it's a little bit tougher because oftentimes the plaintiff, the person has been providing services to somebody for many, many years. They don't even realize names have changed. They think they're working with Johnny and his hay specialty company, and then come to find out specialty hay company hasn't existed for years. So it's really important to get that correct name, because if we file suit for Johnny's hay company and it doesn't exist anymore, it's a completely empty judgment. That's not to say we can't do things to try to fix that, but it's just much easier and less expensive if you make sure that the correct name is on the invoice that you're billing for and that you know the parties. So if it's a corporation, it just takes a minute to pull up the Secretary of State website and double check that that entity still exists and it hasn't dissolved before we start trying to file suit. The other thing is if they claim to be a partnership, try to get the names of all the partners, because all of those partners are going to be individually liable if it's a general partnership. If it's not a general partnership, then we at least want to know the names of the general partners. So I can't express that enough, because we have that problem so often when we're trying to file suit as to who we can sue. With the credit application, make sure you get all the information on there. If it's important enough to be on the form, it's probably important enough to get the information. And I would also suggest verifying that information. If they give you references, call the references, because they may think that reference is going to give them a good reference, but they may actually have something else to say to you once you call them. If they're a large customer and it's reasonable, you may want to go to their business and talk to them and meet with them. That's going to also help you identify who the people are who are authorized to make purchases and who's going to be liable for the debt if they don't pay it. The other thing you can do, of course, is check their credit references, their credit bureau rating. That's particularly for consumer debt. It's a little harder for commercial debt, but you may, if they're a large enough customer, then you may be able to check them on Dun & Bradstreet. The other thing is personal guarantee for a commercial debt. We strongly suggest that you have a separate guarantee for a personal guarantor. Oftentimes they're put inside the original contract. There is some case law out there that is not favorable for creditors. Not saying it isn't going to pass, but it's better if you have a separate personal guarantee. And of course, if it's in writing, it's always better if it's in writing. Not that oral contracts are not enforceable, but binding, but the terms are a little harder to enforce. So it's better to have them in writing. Darryl?
Yeah, let me go back on a couple of those things, Allison, if you can go back and just keep it there. When we talk about getting information, those of you who are in business, not in banking, well, actually in banking too, but mostly who are selling your goods on credit, there's a tension between sales and credit. And there's always the people who want to make that sale and get that product out as quickly as possible. They don't really care whether or not the person is credit worthy and will be able to repay. They just want that sale. And your job as the credit manager is to make sure that the people actually can repay for the goods. And so when we talk about getting information on the credit application, both Sheryl and I have seen it where they'll have the name of the company and an address, no phone number, no other information. So half the time, no signature on it. That's not enough. We've seen situations where people are in the construction industry and they send a contract off. They get the go-ahead, they build the whole project, and then they realize they don't have a signed contract in their possession. So first of all, get the right information. Get the right information on the credit application, fill it out completely. If they're refusing to give you the information, that's telling you something at the inception of your relationship. That's telling you they're hiding something, and that now becomes a question on whether you want to do business with them. So it's really important at the beginning. Sometimes it's okay not to sell to somebody and not have to collect your money than to try and sell it and hope that you collect your money. And we can't mention that enough. Also, what Sheryl says is true. Don't just trust them. Go to the Secretary of State's website. See if they, you can't believe how many customers of yours have been going on year after year, and they might be suspended by the Franchise Tax Board for non-payment of their taxes. They're still doing business with you because You have to go in, and it reminds you, check every year as if you're renewing a credit line. Are they still good for the credit? Has their business changed at all? And on the credit agreement, it says documenting that what Sheryl says is true. If you get a commercial, one of those standard credit agreements, it'll say, by signing this agreement, you hereby guarantee the debt. If you're a corporation, you hereby agree to pay the debt. They aren't the greatest things, but they're better than nothing. But if it's for enough product, if it's in the tens of thousands or hundreds of thousands that you might be giving them credit for, get a personal guarantee from them. Prepare a formal agreement. Also, make sure you get the ACH signed so you get paid automatically out of it. And then one of the things that we remembered at the very last minute that's on the bottom of this is it says bill promptly in an understandable format. I can't tell you also how many professional service corporations there are, accounting firms, law firms, architectural firms. Their cash flow, in order to have it consistent, you need to bill consistently, but they don't because they're busy or is beneath them or whatever. If your company wants to get paid, you have to make sure to send the invoices out when you sell the product and make sure you follow up on that. So make sure you also bill on an understandable format. Why don't we move on now? And go on to the next slide. Thank you. So you now have the credit application. You've been selling widgets or whatever product it is, and all of a sudden, and you're looking at you're doing a good job. You're looking at your accounts receivable reports every 15 to 30 days to make sure they're getting paid, at least every 30 to 45 days at the latest. And all of a sudden you notice somebody, hey, this person hasn't paid in a while. That's a sign. That's the time to get on the phone and say, is there a reason we haven't received payment yet? Their response is going to be telling for you, because sometimes they're going to be telling you, you know what, we put the payment, we have proof of it. I don't know why it hasn't gotten to you. And by the way, in this year of COVID, or the last 12 months of COVID, we've seen the Postal Service deliveries slow down to the point that even if you have an electronic checking, online checking that you're sending out payments, it's telling you the checks they're mailing may be delayed by the mail, so make sure you get them sent out earlier. So slow payment could just be the mail, but it might not be. You have to check on it. If you have return checks, one every 2 years means it's an innocent error. The first one, though, you have to take seriously. Why did it happen? And do they make it up right away? And by right away, it's like, I'm really sorry this happened. We realize it came back from the bank. We've already sent you another check. That's telling you the company's on it. When they don't get back to you and you're sending them a letter and they're still delaying you, they're telling you they have a problem. The non-payment is worse than a slow payment. You have to follow up with them and contact them, and you're identifying this as an issue. You're sending them invoices. They're coming back in the mail. What we tell people is, if you aren't doing it already, when you're sending out invoices, you can actually put on your letterhead underneath the return address, address correction and forwarding requested on your envelopes. And if the customer's moved, the Postal Service will give you the new address. If you read in the newspaper that the customer closed, that's a pretty good indication you have trouble. But or some article about them trying to raise money using GoFundMe. We've seen that for businesses that are in distress. The increase in the amounts receivables, and in addition to not returning when you're getting return mail and email, the customer is not even returning your calls anymore. So that's definitely an issue. It's telling you, it should be setting off bells and whistles. It should be telling you to stop providing them with any more merchandise until you get this sorted out. Let's go on to the next. And Sheryl, why don't you talk about steps to take if a collection problem arises?
Right. So I think the obvious first step is phone calls. And typically they won't even accept a phone call, but sometimes they will. And then I would say try to hold their feet to the fire with exactly when are they going to pay, how much are they going to pay, when's it going to be paid, and continue calling. When they quit accepting your calls, I think it's good to send a letter. If for no other reason than we file suit, we can show the court that you've taken the necessary steps to attempt to collect the debt before filing. I think it's small claims, I think, is a really good source for small debt. $5,000 limit for businesses, and after a certain number are filed, then it's limited to $2,500. But it's the fastest way and probably the least expensive way to get a judgment. And then once you have a judgment, you can send it to us and we will help collect. And of course, the first thing we do is a bank levy or a wage garnishment. If it's a consumer, we do a wage garnishment and maybe a bank levy. With a commercial, we then do a bank levy, and that oftentimes gets their attention. You can hire a professional collection agency, and I know that works well with a lot of businesses. We are not as much of a collection agency, although we are identified as one, as I like to consider us. We're the end of the line and we just sue. I don't like to spend a lot of time making phone calls or sending letters because you guys have already done that. And let's just sue them. And that's the next and best way to get their attention. I'm sorry, there was something else I was going to add to that. The other thing, of course, is the alternative dispute resolution, which Darryl's going to talk about, which I think is a good method if you can get the debtor into it, and depending on the cost. But if you're, well, I'm going to let Darryl talk about that. I'm sorry. The other thing that I jumped over was look at the debt and find out if it's something that's worth spending money on, because the last thing you want to do is throw good money after bad. And if it's a debtor that what I call a professional debtor and they're not going to pay their bills, it's probably a good business decision to just write that off as a cost of doing business and move forward on files that you will be able to collect on.
All right, let me go back. Allison, please. Thank you. So I want to amplify some of what Sheryl said. You've all faced it. If you sold anything, somebody's not going to pay you at some time. Even if you're a high school kid going around mowing lawns, there's going to be that one owner who doesn't like the job that you did and is going to stiff you. And so you learn at an early age that life is full of disappointments. But one of the things we notice is, as Sheryl said, professional debtors. Our experience has shown there are two classes of debtors. There are people who use the legal system as a tool of commerce and to bludgeon people with lawsuits, to misuse it in order to get you not to try and follow up with payments, who threaten, or who just like to buy stuff and never pay and are very smart about hiding their money. There are some people who are really good at taking money from one person and taking goods, converting it to money, keeping it, and making it difficult for you to collect. There are other people, the largest group, I would say over 70 to 80% of the people you'll deal with are people who, gosh darn it, they just had a problem in their life. We have a partner here who talks about life is tough and being a lawyer is tough, but just life is difficult. And for some of them, they have illness in the family. They have other issues going on with their family that they have to deal with. They have difficulties in the business. They may have had embezzlement. We've had situations where the bookkeeper has embezzled money and leaving the company without enough to pay their bills as they become due. Just all sorts of difficult issues like that. And you have to identify early on, what type of debtor is this? And then you have to gauge what you want to do, what response you have, depending on the type of debtor you're facing. If they're, and I'm just going to say, a crook, somebody you know is not going to pay, but may have assets, don't mess around with letters, calls, anything. Because the longer you wait to take action, whether it's sending it to a collection agency to sue or to a law firm to sue, they're taking your money and they're spending it. For those credit managers out there or people who deal in credit or trying to collect money, I know that nothing's more frustrating than hearing this sentence when you ask them, when are we going to receive payment? I don't know. It's been really tough. Let's talk after I come back from Hawaii, my vacation in Hawaii next week. Or they're going somewhere else that has nothing to do with their trying to get money in for business, and they're just taking your money. You may need to take action quickly. Don't wait. Don't hope for the best, because it's just not going to happen. They just respond. You have to take the money from them, or decide I'm not going to waste my money. Because once they have your goods and they converted it to money and you're trying to collect it, it becomes, for some people, it's a salvage operation. That's why we talk about at the very beginning, get the correct information on everybody. Because the more information you have, including their bank accounts, means that we can go after them and try and recover them. If Sheryl gets a judgment, I think it was you, Sheryl, who we had one person who we levied on their bank account, and they thought it will never happen again. And they left the money in their bank account, and we went back a second time and got the rest of the money. So getting the information on where their bank is located and taking quick action was really key to it. Small claims court is also really important. If you have a $7,000 debt and a lawyer is going to charge you $2,000, and you can go in for $5,000, why not save the $2,000? Don't use a lawyer. Go to small claims court. 45 to 60 days, you get a judgment. Then you can talk to a lawyer about how to levy on it. Collection agencies do work. Most of them, however, will, in order to keep their costs down, not want to hire lawyers. So they'll do letter writing and calls, and they may not be as effective as lawyers. There are some lawyers who have collectors in house, but mostly for consumer collections on credit cards and high volume debt like that they get from debt buyers. For lawyers like us, we generally will send one demand letter and then file suit. We are not collectors, but we will work with them. But you can take action at that point in time. And you can also talk about negotiating at that point in time. So let's move on to the next area, which is the legal remedies. By the way, there are illegal remedies. I want you to remember, don't use them. For those who get really frustrated and realize that a bullet's cheaper than a lawsuit, don't do it. Sheryl and I discussed it this morning. It's still illegal. You can't do that. I was going to show a Family Guy clip of their collection efforts, which was Stewie beating up the dog Brian because he didn't repay a debt as if he was a gangster. Can't do that either. It was funny, but so let's talk about what your legal remedies are, and they're pretty simple. One is self-help, which is let's say that you sell something secured, and to the extent that you sell goods, and to the extent you're going to continue to sell goods, anytime you sell goods and the person may not pay you, you have a right to contact that person, deem yourself insecure, say, look, you were supposed to pay me in 10 days. You haven't paid me in 10 days within terms. If you don't, unless you provide adequate proof that you're going to be able to repay me, I have to take back my goods. And that's called rights of reclamation. If you are a lender and you make a secured loan, or your credit application includes a 1-paragraph security agreement that I hereby grant you, and here's the magic terms, I hereby grant you a security interest in the following collateral, and you can identify the collateral as any goods that you sell to them. You have a right to self-help to go in there and recover the collateral, only if they let you. As soon as they say no, then that's trespass if you try and collect it anyway. And you cannot go out of the property. The other self-help that's not up there is negotiating with your customer. It is a form of alternative dispute resolution. It's the first one we recommend, which is actually talking to your customer and trying to work out a payment plan. Oftentimes that works, especially for those debtors who are really just in over their head because of some circumstance beyond their control. And all too often, I hear people that they want the money now. They gave the goods, they want the money, they need the money, etc. And we all could use the money now. And you want to use the easy payment plan, which is one lump sum payable now. But some companies do get themselves into problems, and then you have to renegotiate the debt. Remember to keep that as your first option. If you can get them to pay over 3 months or 4 months, or on a COD plus system, to get caught up in 4 to 5 months, you're going to be way ahead, because in lawsuits, if you file a lawsuit, you won't get heard for 1.5 years. So you have to think at the back of your mind, what's important for me to get the money, or for me to be right and show them how tough I am in a lawsuit. Lawsuits may be necessary later on, but when you're negotiating, remember you can negotiate the terms. In fact, when you negotiate your terms, you can ask them to sign a promissory note for the amount that you're due. And you can secure that promissory note. We've seen customers take their unsecured debt and put it in the form of a promissory note to pay it back over time. If you do that, remember you can only collect 10% interest, while on a trade debt, you're entitled to ask for up to 1.5% as a service charge. But on your promissory note, you can get interest well above what you can get in the bank. Anyway, up to 10%. You can structure the terms. And now you have a promissory note to sue on instead of just your credit application. Now you're in a stronger position if you have to sue. In addition, you can, let's say you sold to a corporation at that time and they haven't paid. You can now, instead of having to get a guarantee and they're going to structure the debt, you can have both the principals of the company sign the promissory note along with the corporation, or get a guarantee to make sure the promissory note's paid. And so remember that you have these options. I had clients call me so often early on, why should I take the money now? Why should I wait 6 months or a year? That if you go to our website, there is an article. It's entitled, Should I Take the Money or Sue? And the analysis became an economic analysis that a lot of companies don't make because it becomes emotional to them. And the analysis is, for the honest debtor, the one who just needs help, you're going to be way ahead. Because the way you're going to structure a settlement is, in your legal remedies, if you file a lawsuit, is they're going to come to you. We're going to be able to do what's called a stipulation for entry of judgment. And what it's going to provide for is they're going to acknowledge the debt, the full amount. And then if they're going to pay a lesser amount, like let's say you give them a discount or 10% to pay quickly, or whatever it is, you'll put in the terms of payment. It'll provide, if they miss a payment, you can go into court on declaration from somebody from our office and get a judgment. So now you're 45 days into a lawsuit, you settled. But more importantly, if there's a default, you'll know if they're honest or not. This works even for the dishonest debtor, because they'll sign anything. They'll tell you anything. You sign the stipulation. If they don't pay the first month, now you go in and get a judgment on your stipulation. For the honest debtor, they'll make the payments. They don't want to have a judgment against them. So you've given them an incentive to pay you off. And for those who just get into problems and can't get out of it, you still get a judgment quicker. And so just think about that on the back of your mind, about the benefits of settling. I had one construction client years ago. Subcontractors would sue. They claimed that they were owed money. They weren't. It was easy to prove they weren't owed money. He just said, you know what, if it's within my budget, I'm going to settle them. I'm not going to hire a lawyer. It's just not worth it to me. Other ones will hire a lawyer. So we have self-help. And then the other is, with self-help, we you can have a lawyer enforce your rights in court. So you have a lawsuit, or if your agreement contains a provision that says you will arbitrate, we can go to arbitration. There are benefits to going to arbitration and detriments. If you go on our website, there is an article, several articles on ADR, one ADR, what it is and why you should be using it. And then there's another one on the pros and cons of arbitration. Figure out what's right for yourself after reading them. We can also advise you. But in some instances, arbitration is quicker. The cost is almost the same now because arbitrators are charging so much, but it's quicker and binding. Court is different. You have a right to appeal. Anyway, so we have a lawsuit you can file. The claims are breach of contract. And whenever you hear a lawyer say money on common counts, what that is telling you is it means it's an implied agreement. You don't have it in writing. What you have is a credit application, and you have accountings, and you have the invoice, the statement of account, and you're allowed to sue on those as evidence that you have a contract with the party, that they buy the goods they're supposed to pay you back. And then another claim is if you have a secured debt, you have a right to claim and delivery. In California is the remedy. It's also called replevin. Sheryl, have you used replevin in collections, and explain when you would use that?
Right. I think we're going to jump into the next screen as well.
We will in just a minute, but have you used replevin for your?
Right. It's actually called claim and delivery now. And so that would be picking up if you have a secured interest in a vehicle, in a truck, in inventory, in equipment. The court allows you to pick it up as long as it's done peacefully without even having to file a lawsuit.
So there are remedies. So let's go to the next section. No, or the next slide.
So that's right.
So in talking about the remedies, as Sheryl said, you're jumping ahead just a bit. The law, whether you arbitrate or not, you're entitled to certain provisional remedies. Provisional just means prior to judgment, but we have to use special words. So that's why you use provisional. Anyway, so one of them is the writ of attachment. A writ of attachment is, and just to be clear, for our clients, I try and explain, a writ is just any instruction to a government official. So a writ of attachment is an order directing a sheriff to attach the property of a debtor prior to judgment. A writ of possession, it's just like it sounds, a writ directing the sheriff or other governmental authority to take possession of certain collateral. A receiver catches footballs. No, it's actually not that. A receiver is a third party appointed as an officer of the court to take control of the assets of the debtor and run the debtor's operation until so they can get the monies collected and pay off everybody. And then another option is foreclosure. And if you have an obligation, a debt secured by real property, even if it's also personal property, your sole remedy is to foreclose on the real property. If you have a single family home that secures your debt, and that money that you're trying to collect is the money that they borrowed to purchase the property, it's called a purchase money first. Your sole, you can do a foreclosure, judicial or non-judicial, but you cannot collect a deficiency. On a commercial debt, you can actually collect a deficiency if you perform a judicial foreclosure. Sheryl, you want to talk about the writs of attachment or writ of possession what you do in your practice, please?
Okay, a writ of attachment is an unsecured debt, and it has to be a business debt. And it's very helpful in that it brings the debtor to the table very quickly. They're not as likely to ignore the debt, because basically you have to prove to the court that you're more likely than not to win the lawsuit and get a judgment. So if we can prove that to the court, then the court will allow you to start levying property, actually taking possession of property before judgment's entered. So we could do a pre-judgment writ of attachment. The court could find that it's more likely than not that the judgment will be entered in your favor. And you can actually levy bank accounts and take money. It'll be set in a court account aside until judgment's entered, unless a bond is entered. And you can lien real property, you can lien assets, and the debtor gets a little more excited about that, and they're more likely to settle. And we have found that to be very beneficial, but it is a little bit more costly, and oftentimes creditors don't want to expend the cost. The other is a writ of possession, and that's where you already have a security interest in the property. A lien on a vehicle, a lien on a truck, lien on trailers, lien on inventory, lien on receivables. And so again, the court, because you already have this lien, you don't have to prove, or more likely than not, that you're going to obtain judgment. The court says you have a lien, you have a right to it. All you need to prove, for the most part, is that they're in default. And then the court will issue a writ of execution at that point, and the sheriff will go out and pick up the property. So we've had sheriffs pick up inventory. We've had them pick up office equipment, office furniture, depending on what was a secured interest. Oftentimes it'll be pursuing items that have UCC liens have been put on them. And of course, if it's a vehicle or a truck, we'll send the sheriff out to pick it up. The caveat to that is for things like a vehicle that is very easily movable, we have to know where that vehicle is located before the sheriff will go out and pick it up. If the vehicle is behind a locked gate, we may have to add an extra provision in that writ of execution that says the sheriff is entitled to knock the gate down, kick in the door, force the garage open to take the vehicle. But again, we need to know where it is. The downside to that is oftentimes the sheriffs want to hold it for 20 days and give the debtor an opportunity to pay for it, which again is fine. If they pay for it, that's goal accomplished, but it can be a little expensive. Typically with vehicles though, the sheriff will just turn it over to the creditor, have a repo company present, take the vehicle, and it's then in the possession of the creditor. So it's two different types of items to accomplish the same thing.
And let me just add, sometimes the remedies are not mutually exclusive and can be used in tandem. We've had situations where we know the value of the collateral is less than the debt. Especially true in trucking companies will borrow money. We do a lot of work for banks and finance companies. Trucking industry has been really hard hit. We have been asked to recover the fleets. We find that 6 of the 11 trucks can be recovered. They're in terrible condition. The other rest of the trucks can't be located, but we know what the deficiency is going to be. We can actually go in for a writ of possession. And then we can also seek a writ of attachment for the unsecured portion, the amount of the debt that we believe is going to need to be collected afterwards. The writ of attachment can be very successful when the downside of a writ of attachment is whatever the sheriff can levy on or lien cannot be turned over to you until you get a judgment. And then once you get the judgment, you let the sheriff know you're done and they have the money in hand. So years ago, we represented a leasing company. We went for a writ of attachment. We went for a writ of possession. They turned over the collateral. We then went for a writ of attachment for the balance. We found a CD that the debtor had. We levied on it. This is 20 some odd years ago when the money was worth a little bit less. There's a $20,000 debt, $18,000 debt. Our client had agreed to take $13,000. The debtor wanted to fight. He ultimately paid $33,000, and we collected it because we had it in hand with the writ of attachment. On a writ of possession, the other benefit of a writ of attachment is that if you obtain a writ of attachment, you can get it against the guarantor as long as they're intimately involved in the business and they signed a personal guarantee, as well as the corporation. And you can go after all assets of the corporation, including accounts receivables and inventory. So we also had a client who ran a pharmacy. We were able to just repossess the entire inventory, and they thought we weren't going to do it. And when we sent the sheriff in there, it changed their mind. That we can also do it in a prejudgment till tap, where they'll go in there and they'll take the money from the cash register. If it's a cash business, now it's no longer cash. But also, let's say you get a writ of attachment and you want to find out where all the assets are. You could say accounts receivables and such. You can actually bring the debtor in for a judgment debtor's exam for him to tell you where the assets are that you can secure, where you can levy on the writ of attachment, even before judgment's entered. Normally, discovery, you can't ask about finances, but to levy on a writ of attachment, you can. On a writ of possession, the benefit of that also is there's a checkbox in the order that says that if you ask for it, you can order the person to actually turn over the vehicles to you. So let's say you have a sole proprietorship or a partnership that's holding your inventory, your collateral, and you check that box and you get the order. Then the next thing you can do is say, okay, now you got to turn over your collateral, or we're going to enforce the order by an OSC rate contempt of court. Order, OSC just means order to show cause. It means, hey, defendant, you're being brought into court to explain to us why we shouldn't find you in contempt. So you get that writ and you say, tell us where your trucks are, turn over your trucks today. If they don't, that's a violation of a court order. Judges take that seriously. And if you don't answer the questions, there's a bench warrant available. So that's important. On an ongoing operation like a hotel or a packing house, and you need to enforce your debt, you're going to have part of it secured by the real property, part of it secured by the commercial property. You have to take steps to do the foreclosure in the right way so you don't lose your right to foreclose. And what's interesting on a commercial debt, just as an aside, for those of you who don't believe guarantees are important, if the person is pledged, if the corporation's pledged real property as collateral and you have a guarantee, and the house is foreclosed on, their property is foreclosed on a commercial debt, on the guarantee, you can then sue the guarantor for the remaining balance owed. The normal rules for foreclosure are that you have to go on a judicial foreclosure, have the property ordered foreclosed, then do a fair value hearing on what the value of the house was. And then whatever you collected on the house and the fair value, if there's a deficiency, the court will set the amount of deficiency. You can then collect that money from the debtor. And then they have a year to try and buy back the property. So you can tell it's a hassle. If they've signed a guarantee, you may not have to go through the non-judicial foreclosure aspect of it. And instead, what you're going to be able to do is just sue on the guarantee. So there are benefits to doing that. I had a caveat in there also: be careful of inadvertent election of remedies. And that what that means is if you sue and then get a writ of attachment and enforce the writ of attachment, you've now said, I'm just going to sue on a breach of contract claim, because that's all you can get a writ of attachment for. Same thing on a writ of possession. You've elected your remedy to go after. You can still get damages under claim and delivery. You can get the collateral or its worth in a judgment. But be careful that if you really have a good claim for fraud or conversion, getting a writ may be important, but you may be precluded from getting damages for conversion and such. And before we move on to the next subject, I wanted to, Sheryl and I realized that we left off something off the PowerPoint, which is special provisions. There are certain remedies available to certain industries that aren't available to all of us. For example, if you work in the construction industry, if you are providing value to an improvement of real property, you're the contractor, subcontractor, material supplier, design professional, or laborer, you're entitled to a mechanics lien and stop notice. Those are additional remedies that you have. And when you file a lawsuit, if you have a mechanics lien, you have a right to foreclose on the real property that is being improved by your work. There are also for tow companies and repair facilities, storage and repair liens. What are those? Just briefly, Sheryl, you're familiar with those?
Right, and I usually am working on it more of a creditor standpoint, but if a tow company wants to charge storage fees or a mechanic wants to charge repair fees, they need to either get approval from the lien holders if there is one. And if they have not obtained approval, then they need to or will have to do a lien on the vehicle. And to do that, they need to timely serve those notices, timely give notice to the DMV, or they're going to be foreclosed. And that happens very often with small repair shops because they're just not familiar with the law. And then they're limited to $1,500 for repairs and $1,250 for storage fees. And this happens very often. So it's if you're in that particular industry, it's very important to know those laws. They're very, very unique and very specific.
Right.
There's also liens for homeowners associations and common development associations where liens can be placed on the property. And again, they're very specific and unique, but it's certainly worth knowing those provisions because it's one of the only ways to get paid.
Right. So, and just on the storage and repair liens, if let's say that you're a bank and you're making auto loans or a finance company doing trucking loans, and half the time you want to repossess your collateral, it's in some sort of a storage yard or repair facility. They may be asking, we have one recently, they asked for $12,000. They never sent a notice of lien. They never sent notice that they had the vehicle. They're required to do that within a very short period of time. And then they realize they have no rights to a lien. And so you should be aware of those remedies also in case you think that you're owed money and your collateral is in some sort of a storage facility like that. You think, well, I have to pay it to get out, to get this property out, don't I? No, you may not have to. As a matter of fact, there's law out there that if you tender the maximum amount that's owed and they reject it, they have waived their lien. And we've used that successfully to get a equipment back, collateral back for auto loans. For those in the ag industry, there's Perishable Agricultural Commodities Act, PACA, which gives very special rights to those who produce the goods, because you get a non-segregated lien on any assets that the buyer, anybody on the entire chain gets. So if you sell it to a broker who gets paid, they owe you, and that broker sells it to another company, and let's say it's a commissary for a supermarket chain, and they pay the broker, but you don't get paid, they're liable to, and then they sell it to a supermarket, they owe you to, and it's interesting. It reminds me of the old Get Smart, or National Lampoon's Animal House, where they had the double secret probation. There's actually a secret lien that's available also. And just so you know, in post judgment, there are liens that if you get a judgment, anytime there are liens that you can place. There's a judgment lien that you can place on any personal property, similar to UCC 1. There's an abstract of judgment. You can place a lien on any real property. And then when you ask for a judgment debtor's examination, there is a secret lien that is placed on any personal property that the debtor may have that is brought in. They're prevented from disposing of anything during the time between the time that they're served with the application to the time that the debtor's exam is completed. And just as an aside, in federal court, the judgment debtor's exam is not completed until they've answered every single question you ask for. They will keep having the debtor come back if you need one more piece of paper. State court's not as giving. And then the last is another special remedy is available to those in the beef and poultry industry. The Stockyard and Poultry Act gives you remedies similar to PACA, where you have a special lien. So let's move on to the next slide, which is, let's say that, what other options are there? And when I first started practicing law, there were litigators, there were transaction lawyers, and the litigators went to trial. And heck, if you wanted to settle, you'd settle. And mediation was rarely, if ever, used. You would have a settlement conference a couple of weeks before trial, and the judges half the time didn't care if you settled. They were ready for a trial. Now they require you to mediate. So alternatives to mediation, to litigation, should always be considered. There are benefits, cost benefits to every business. The first one is negotiation. Not enough people negotiate first before they give it to a lawyer, but that should be limited to 30 to 45 days after you really have a problem, to make sure that if they're going to settle, they'll do it within 45 days or so. If they don't, you may want to take action. Mediation is the use of a neutral third party to help to facilitate a discussion to come to a resolution. It normally involves compromise. They believe that this especially works well if the other party believes that there were defective materials supplied to them by your company. They weren't, and they owe you the money, but that there's going to be some compromise, but you can't figure out what that amount is. That's really good. Arbitration is the use of a neutral third party to make a binding decision. Some contracts, or your contract, can require binding arbitration. Remember, though, that if you want it to include binding arbitration, it has to be set forth in your agreement in a clear and conspicuous manner, not in fine print on the back of a form that they may never see. And then I also have in here judicial reference. For those in the legal industry, it's called rent a judge. For those who aren't, it means that you could, in lieu of, let's say you have a very big debt, it is very hotly contested, but you want it heard and the courts are being really slow, you could actually agree with the other side to hire a retired judge and put on a trial as if it were a regular trial. In fact, the courts may even allow you to use a courtroom that's empty to do your trial. And that's judicial reference. Some banks used to have that in lieu of arbitration, to have judicial reference. But, and in commercial cases, it can work well, but it's very expensive because you're already in court, you're paying for the judge, it's very expensive. You have all the same discovery that you would have in a regular lawsuit, which is expensive. And you're having this rent-a judge charge you every time to make a decision on anything. But for a large enough debt, it gets you done. And it's important to keep in mind. That being said, oftentimes you can use the same judge for a mediator, half the money. They don't make a decision, but they can help you resolve your dispute. We're kind of going now to, I'd like Sheryl now to discuss bankruptcy.
I can't emphasize enough, when somebody files bankruptcy, you receive notice, and look at the notice, particularly if it's a Chapter 7, and see if it's an asset or no asset. Typically, it will say no asset, don't file a creditor's claim unless you're given notice, and continue to monitor that, because oftentimes they have assets and you will collect something with doing nothing more than filing a creditor's claim. So, and many businesses, once they receive the notice, they close the account and they're done, which means there's less people. If you file a creditor's claim, there's less people to share the money with. And it's not unusual for a 7 to have assets to be paid out. 13 is a reorganization for individuals. So if the individual doesn't qualify for a Chapter 7, they make too much money, they have too many assets, then they will also use a 13 for reorganization. And again, it's not unusual to have a bankruptcy where the non-secured creditors are paid 70, 80, even 100 cents on the dollar, and it takes very little to file a creditor's claim. We'll file it for you if you need help, but oftentimes our clients will file it themselves because it's not a difficult form. Basically, they want you to state how much is owed and support for it. So if you put down they owe $10,000, attach a couple of invoices, and it's not taken very long to do it, you will potentially get paid something at the end of the day, as opposed to just tossing it aside and ignoring it because they filed bankruptcy. Chapter 11 is a business reorganization. And the thing to note about businesses is they don't ever get a discharge. So even once their bankruptcy is completed, they are not discharged of that debt. The reality is most businesses are no longer in operation, but some of them are, and that debt's not discharged. So again, it's very much worth a few minutes to fill out a creditor's claim and submit it. We have one construction client. We always fill it out for them. And usually at the end of the day, they're the only one to recover whatever money's being paid. So it's been worth their while to fill them out because so many people don't.
On the next slide, I think there's one more, is there? No.
There's
Did you already cover these, Sheryl?
I don't think we have covered those. I was just going to comment the other bankruptcies where the 11 was the farmers. I personally have never worked with farmer bankruptcy, but I know that can be a major issue. With bankruptcies, there's also a thing called the automatic stay. So people file bankruptcy oftentimes to stop their creditors from being able to call them and contact them. So once they file, of course, you should never send them another letter, never call them, put a flag on the account so that there is no further contact with them. Another thing with the relief from stay is you cannot attempt to take their vehicle or any other assets during that stay. There are exceptions to the stay. So if they file bankruptcy more than 3 times, 3 times there is a period of time for the stay, and if they're 4 times, there is no automatic stay. But other things that you can do in bankruptcy is object to the plan. For a Chapter 11 for individuals, you can object to the plan, look at the plan and see how they're paying out. If you don't object to the plan, then you're stuck with the plan forever until, of course, potentially amended or discharged. But it's very important to look at what they're claiming are their assets, and you may want to do a motion for relief from stay. Could do that before or after the plan. I'm sorry, I'm kind of jumping around there. A motion for relief from stay would be, for example, if there's a vehicle and they have 2 vehicles, it's not needed for the plan, they're not making the payment. Motions for relief are fairly quick and can obtain relief from the court in a fairly short period of time, where the court will order them to turn over the vehicle, or you can return to state remedies to recover the vehicle. It's important to look at the plan and see how they're treating the creditors, see what kind of assets they have, because oftentimes we do want to object to a plan. And then there's another option where the debtor can just abandon the property and the creditor can pick up the secured assets. But I do think it's worth creditors taking a few minutes, and we can take a couple minutes with you to look at the plans and look at their petition and see what their assets are and what they're attempting to do in the plan or in the bankruptcy.
All too often, just to add, thank you, Sheryl. All too often, what we see is creditors get notice of a bankruptcy and they're owed, $50,000 to $100,000. They have other creditors there. First of all, if you believe there's fraud involved with the people, and there are, we had a notorious one. We were collecting money for a client in Southern California. It's still going on, unfortunately, almost 8 years later, because the debtor is just a horrible human being. Keeps suing. But in bankruptcy, it was clear that he was lying. He didn't disclose all of their assets, didn't disclose a lot of facts. The trustees have a lot of power. They can order the person to answer questions. But in a bankruptcy, you have a right to take a deposition of the debtor if you want to find out if you think there's assets, or you think that you might have a chance to recover money because you know of a transfer of property they made that they haven't disclosed. You can go to the first meeting of your creditors. Every bankruptcy is going to have one. In a Chapter 11, you also, in all the bankruptcies, you have a right to what's called a 2004 examination, a deposition under Bankruptcy Rule 2004, where you can ask them questions about any of their assets and what they did with them. Because you may have known about assets, they may have listed, they may have given you a financial statement. You're a bank, they give you a financial statement, and 9 months later they're bankrupt after they said they had $10 million in the bank account. What happened? If they lied on your financial statement, then they may be prevented from getting a discharge in bankruptcy. If they took the money and there are debts that are non-dischargeable. If you've been defrauded by somebody, then who wants to file a Chapter 7, they may not get their discharge. In which case, your judgment, you can keep a judgment on them for renewed every 10 years and try and collect the money from them. I can't tell you how many times we have recorded an abstract of judgment and a judgment lien and renewed the judgment, and 10, 15 years later, the people realize they finally have to clear it off their title. They're selling real property. They tried to stiff you for that many. Now they have to pay you, and that includes interest of 10%. They don't have it if it's not their homestead. They have to pay it. They don't get a homestead exemption. So there's a lot of things that can happen, and in the bankruptcy, if you may have to object to their bankruptcy itself. So each case is different. And again, for the legitimate debtor just gets in over their heads, you're going to know it's not worth chasing them. They need a fresh start. For others, they're crooks, and you're going to realize that there are steps that you can take. With that, do you have anything else to add, Sheryl, for the?
No, I think the one thing we probably didn't put on here was post-judgment abstracts. And I think abstracts are incredibly important, as Darryl said, is years later when they pay the house, their creditors will get paid, or oftentimes will get paid, and can be paid a substantial amount of money. So I think abstracts are a huge item that creditors can and should use once judgment is entered.
Right. So now's our time. We thank you for your patience. We went a little bit over. We said 10:30, but it's really, we're trying to get you out of here. We know you have important business to do. I urge you in the chat box, if you have questions, to let us know now. If there's anybody who has a question. If not, go to the next page, next slide. There are our contact information for emails. Please, if you send us an email question, we don't charge for them. Unlike many firms, we want you to be protected. We want to give you information to know whether you need to hire a lawyer or not. So please contact us unless it requires significant thought process. We generally don't charge for prophylactic phone calls. Also, what will happen is you will get a letter, you will send out your demand. You'll get a response from the lawyer. If you have a question about the lawyer who's responded, are they good, bad, indifferent, and want to know a little bit about them, please don't hesitate to call us. We're here to try and help you. And with that, unless there's any questions, thank you. Our next webinar will be in May. We're going to skip April because it's tax season, but we're going to go to May, and it will be on wage and hour laws. If we move it up, we will let you know, but please stop by for our next webinar on updates on wage and hour laws.